Thank you so much, everyone, for joining us today. Thank you very much also to the GenZero Climate Summit Insights 2026 team. We're so pleased to be here. So to jump right in terms of today's panel session, many in this room may have experienced some slowing down of the voluntary carbon markets, whilst at the same time growth in the CORSIA and Article 6 markets. Although entities like Amazon, who spoke on Monday, have been significantly driving voluntary carbon market activity as well. The UNEP, who spoke on Monday, also predicted growth in the voluntary carbon market trades as the market spikes to 2050. From our perspective, this growth may come sooner with the increase of voluntary and mandatory climate reporting, including in my home jurisdiction in Australia, where certain entities are reporting publicly on their climate-related risks and opportunities and the impacts of that on their financial performance. This reporting includes the use of carbon offsets for the purposes of meeting climate-related targets. It will bring into the spotlight the veracity of those carbon credits and whether they can be used to make the specific claims, which will likely result in increased demand for carbon credits that can substantiate the proposed claims. At the heart of this market transition is effective management of carbon project risk. So today we are going to dive into that risk management and what mitigation is available, including insurance and reducing the prospects of disputes. So Kushal, I'll lead with you. So please, can you tell us how have the carbon markets changed in the last few years in ways that people in the audience may not be aware of?
Sure. Thank you for the question, and thank you to GenZero for organizing this session.
No. Otherwise, we can jump to Tom while that gets sorted. I might, in terms of keeping it moving then, Tom? Oh, it's all right? Yeah.
Sorry. So I was saying that thank you to GenZero for organizing this wonderful session. Thank you for the question as well. I think the biggest change is that the market has discovered that just because something is verified doesn't mean it is risk-free. So verification is not a substitute for legal, technical, and commercial diligence, which I think is a realization which was a long time coming, because that would be the case for any other asset. But I think the biggest change is that carbon markets are now moving towards more towards financial capital markets infrastructure like. So you, of course, have KITA acting as insurer, you have a data infrastructure layer being developed, and you also have rating agencies, which is what you would traditionally expect from financial securities, right? And that's absolutely the right way to go because that's what produces trust. I wanted to do a thought experiment, so I'm going to read out 5 sentences that were published in the Financial Times just a few days ago. And I would like the panelists to guess which market they're talking about. So Financial Times writes, we lack a common language that underpins liquidity, including standardized identifiers, documentation, and uniform financial reporting. That's point 1. It says, second problem is settlement and operational infrastructure. Forget about electronic trading. Today's trade settlement is slow, manual, and prone to error. Then it goes on to talk about transferability constraints. It says that in practice, there's uncertainty around execution timelines and transfer certainty. It says, fourth point, information asymmetry and conflict of interest means that secondary buyers of this product do not have any information on project and borrower level data. And then it says the ecosystem is nascent and insufficient to anchor a continuous secondary market. Can you take a guess what product we're talking about here?
Someone's involved in the fixed income markets around 2008. It sounds like a regulatory report on what went wrong. So,
well, I mean, actually, this is a $2.2 trillion investment manager, PIMCO, telling Apollo what it should do to fix the $4 trillion private credit market. So I think for me, that's a very hopeful thing, that somebody else, somewhere else, which has a market which is 4.4 trillion size of the carbon market, is also struggling with the same issues. And so, as the panelists just before us said, they have had 100 years to develop those systems and processes and infrastructure, and we're just 20 years old. That's the big change, and it won't happen overnight.
Thank you so much for that, Kushal. We really appreciate that analogy. So over to you, Tom. What types of carbon-related risks are realistically insurable today, and which remain fundamentally uninsurable?
Well, a classic underwriter response to this is, it depends. But since this is a panel discussion, I should probably elaborate on that a little bit. So to begin with, maybe a quick refresher on the typical types of carbon insurance that have emerged over the last few years. Firstly, there's non-delivery, which is I have bought credits in advance. Will they be delivered under the terms of that contract? Second is non-payment insurance. I have lent some money to someone perhaps involved in the carbon or environmental markets. If they don't pay me back, if they default on that loan, is there an insurance payout that I can seek? And then finally, political risk insurance, which I suppose is typified by Corsia, although that's not classic political risk. But political risk would say, I have an asset in a country, that government have decided that they rather like the asset for themselves, and I can't get it back anymore. So 3 main types of insurance out there. So with that sort of framework, then let's think about how insurers determine what's in appetite, what's insurable and what's not. Firstly, there's the appetite of the underwriters themselves. Do they understand the risk enough to be able to put a price around it? So that might be that they understand nature-based projects in the carbon world, but perhaps they don't understand engineered-based CDR, or maybe some of that technology is still emerging and they don't feel comfortable enough putting a price around it. The second thing is both a regulatory and a reinsurance restriction. So on a regulatory basis, there are a bunch of countries which insurers can't operate in. As ever in insurance, there are exceptions to that rule. The shipping in Ukraine could be a good example. But the reinsurance stuff presents a real limit to what insurers can do. So Kita seeks reinsurance. We get our capacity panel provided by people like Munich Re, people like Tokyo Marines, Kiln Syndicate in London. And they have limits to what they can do. And in turn, they go and seek reinsurance themselves, and that imposes limits on what they can do. So what would be a good example of that? They'll have limits per country, or they'll have limits for certain tenors. They couldn't write over 10 years. Or if they can write over 10 years, then they only have a very small bucket of risk that they can write that's, say, 10 to 12 years, something like that. So they're a bit hesitant to deploy it into the carbon markets where the claim profile is still almost completely untested at the moment. And then the final limitation is that the insurers are building up their own portfolio of risks. So they might find, just like every other portfolio manager, that they've built up a concentration in a particular type of CDR or in a particular country or against a particular developer. And we've already seen now in Corsia how those insurers who are offering insurance in the Corsia markets have bumped into country aggregation limits and now can't write any more against that country or write any more business for that particular issuer. So those are very sort of real limits placed upon that. So, and I think a lot of that is not surprising, but perhaps not obvious. I think the really interesting question will be what will be considered insurable or uninsurable when we sit here in 5 years' time. So insurance products, insurance lines, whole lines of insurance can, or classes of insurance, can go out of favor. Construction risk is a good one that comes in and out of favor. Renewable underwriting for renewables has a bit of a checkered history. At the moment, there's lots of interest in credit insurance, which is insuring the banks for non-payment and other financial institutions. There's lots of capital has been moved into that now, so rates have gone down. That is, the cost of insurance has gone down. It's a soft market. So in the presence of that competition, will underwriters continue to exercise good, diligent, responsible underwriting, or will they feel the pressure to offer policies which perhaps they haven't fully understood the risk, or perhaps they're pricing it below what it should be? And then what will happen to see some of that capital fly out again? It's a bit of a double whammy on the credit side, because your obligor might face a downgrade, a credit downgrade, and your own regulated asset base might face a downgrade. So on the carbon side, what will we see? Perhaps it will be that certain developers may have submitted a lot of claims or seen claims paid against them. Perhaps certain project types will see a lot of claims, maybe biochar, enhanced rock weathering, or other types of CDR types will see a lot of claims, and then in future insurers will be very hesitant to get involved. The biggest fear is that we've really overlooked a systematic risk on the carbon side, and what that would mean is that not only is it just individual bits of the carbon market will become somewhat uninsurable, is that actually the reinsurers who we rely on say, well, we had a good time looking at the carbon markets, but we paid a lot of claims and we don't have any appetite for it now, so we'll take a break from it.
Thanks, Tom. And just briefly on the insurance market for carbon projects, what exactly are insurers looking for when they're pricing the risk of the insurance? And for people in the room that are grappling with the costs associated with that, what can they do in their contractual arrangements to reduce the cost of insurance?
Yeah, so insurers will look at some of the obvious things. So, what's the track record of the developer, for example? Have they successfully worked with this type of project before? Have they successfully worked in this country before? Have they delivered carbon? We'll also look at the insured entity as well when it's third-party insurance. So, have they? It's a bit like our own domestic insurance. Do they have a no claims bonus? There's a strong parallel to that in the specialty markets as well. How has that insured entity submitted claims in the past? Have they worked well to reduce losses? They have an obligation to reduce losses under their policy or minimise losses. Have they done that in the past? So those are a couple of things they look at. But specifically within the contracts, writing third-party insurance, we're looking especially for how those contracts are structured to ensure that there are the appropriate incentives for both parties to meet their obligations. And should those parties face impediments meeting those obligations, that there's appropriate risk management in place to help them overcome them. So, for example, if it's an ARR project and they're reliant on a nursery to provide the saplings, do they have some insurance in case the nursery is flooded or suffers a fire? And those sort of things, that's the sort of the business as usual, the risks during operation that can be easily managed. What we also look for, of course, is what happens when things go wrong, and this is certainly your area of expertise. We like to see clear dispute resolution that is reasonable for both sides to be able to, again, work under the terms of the contract to try and resolve the problem, to try and minimise the losses. And then a point which is also perhaps not surprising but maybe not obvious is that should the insurers pay a claim, we may exercise our right to subrogate into the insured's position and seek recoveries under the terms of that contract. And will we be able to, what recoveries might we be able to seek? That will also influence our pricing and our appetite for the risk. So within the contract, we see a whole range of them. We like to be able to see contracts that are very well structured, that allow both parties to work well and resolve differences. No doubt very similar to the contracts that you put together, Ruth.
Thank you, Tom. And on the what goes wrong, over to Joe. So what are the most common triggers for disputes in the carbon markets, Joe? And if you could share your perspective both from the investor side and also from the corporate end user side, that would be most helpful. Thank you.
Thank you, Ruth, and thank you to the GenZero team for inviting me to be part of this interesting discussion. So the issues that I have seen in my experience have not been very similar to the 5 issues that Kushal raised, but have been more similar to the 3 insurance issues that Tom raised. And so I'd like to divide those issues into 3 areas. Firstly, commercial viability issues, either relating to the underlying project or to the carbon credits. Secondly, what I'll call or refer to as project viability issues, relating again to the project or the carbon credits. And thirdly, government regulatory issues or interference, which goes to the political risk insurance that Tom mentioned, and potentially investment treaty claims. So each of these issues correlates with the type of disputes that we've seen coming up since the introduction of the carbon credit markets in the Kyoto Protocol and the introduction of the UN Clean Development Mechanism, and obviously since then there's now been voluntary standards. First, issues relating to commercial viability. They may be any typical commercial issue, such as pricing, failure to comply with the condition precedent, breach of warranties, any other form of breach of contract. The pricing issues first arose in around 2012, 2013, when there was a lot of uncertainty about the future of the Kyoto Protocol and the first commitment period as it was coming to an end. And whilst that period was extended, the carbon credit price plummeted, and that resulted in a lot of disputes because the price in the emission reduction purchase agreements and the on-sale agreements were much higher than the market price. Many of those disputes were settled, but some of them were referred to arbitration. And in one case that we had, we were acting for a developer of an Asian project where the purchaser of the carbon credits was attempting to terminate the contract on the basis of a breach, but there was no evidence of such a breach. And if there was no evidence of a breach, then the carbon credits should have been purchased and the developer should have received the price for those carbon credits. It went to arbitration. In the end, we did manage to mediate and settle that dispute in favour of our client, and a substantial sum was paid to the developer, reflecting the amount that it would have been entitled to under the ERPA. Now, the importance of this contract is not so much, in this particular case, is not so much in the current environment because pricing is high, pricing is not causing a problem leading to disputes. But what it does show is that the ERPAs and the other contracts are enforceable, and this gives confidence to the market, and I think that's incredibly important. The second area where we've seen disputes relates to project viability or issues with the underlying project. That could be because, for example, the carbon credits are not actually generated, or because there are issues relating to misrepresentation or fraudulent issues relating to the project. In one example where we had, it was again an arbitration, and in that case, the purchaser of the carbon credits was not able to determine whether or not the project was going ahead. The ERPA provides for a verification and a monitoring process. The process and the steps in that process were not being undertaken, and there was no way for the purchaser to be able to determine whether the project was actually progressing. And so they commenced arbitration for breach of contract. Even though the developer did not initially participate in the arbitration, the purchaser was able to continue with the process. In the end, it turned out that the developer had been progressing the project, but did not sell the carbon credits to the purchaser under the ERPA as it had contracted to do, but had sold the carbon credits on the local market. And so in this case, it shows an example of either misrepresentation, and that could have been an additional claim in this particular case, or potentially a fraudulent representation being made. It's not possible, obviously, to double dip in the carbon credit, so this is another risk that could come up in these types of disputes. But again, what is important is to show that the ERPA was enforceable and that there was a possibility for the purchaser to recover and to seek a remedy. There may be challenges with enforcing that remedy because the developer does not have assets, for example. But if the developer does have assets, then you would be able to enforce your arbitral award under the New York Convention in the country of the developer, assuming it's a party to the New York Convention, which in most cases it is. So again, this case shows confidence in the system through the enforceability of contracts. Now, the third area relates to investment protection and regulation, and this is another level of protection that we'll look at in a moment. So I'll pass on back to you, Ruth.
Thank you, Jo. So we did just want to touch on Kushal's views on disputes as well, and to the extent you can give some flavour around mitigants that you see as well, Kushal, I think that would be helpful.
Sure. I think the mitigants for all of these disputes is well-structured contracts. That's what it comes down to. And well-structured contracts doesn't mean that we have a single point of failure where all responsibility lies. Because, as you said, you also have to be able to recover. It's not enough to just win the case, because then you have to go and recover the assets. And I think this is what I see as the current problem. Most disputes will now focus on who was best placed to prevent something bad from happening. It's not that nothing bad will ever happen. Bad things happen all the time in various contractual frameworks. But I think the allocation of responsibility is what the focus will be going forward, right? So who was in the best position to prevent something from happening and who bears the loss? Now, the problem in the current setup of the market is that unlike the financial market structure, who would have a separate role for SEC, who is a regulator, NASDAQ, who's a lister, DTDC, who does holding of title and clearing of the security, and the issuer, like Apple or Google or whoever issues the security. In the carbon market, all of those roles are concentrated. And there are no boundaries between who does all of these 4 different types of things. And therefore, the responsibility and accountability and then the consequence of any failures in any of those steps lies not on the people who have control over all of these processes, but on project developers, on verification bodies, and even buyers. And that is not sustainable. So the way this is constructed is ripe for disputes. And I think going forward, as the market becomes more mature, we have to be able to allocate responsibility in the place where control lies, not where contractually it has been structured to lie. And that's when it becomes sustainable. And we've seen many disputes happen on all of the points that you mentioned: project viability, commercial viability, change of law. And we've been able to manage those before it goes into a full-blown dispute. But I think as we go into compliance markets, it's not going to be enough to have an enforceable ERPA. I think we will need a bigger stack of relationships contractually governed between governments, project developers, financiers, insurance agencies, risk allocation in terms of political risk insurance. And also I want to say insurance cannot be a get-out-of-jail-free card. You still have to take responsibility for technical, commercial, and legal diligence. And this is what we do. This is what we have changed, actually, because the best mitigant to dispute is diligence. Diligence while you originate the project, and then a robust contractual framework with a correct allocation of risk and responsibility when things go wrong. And that's how I see the market moving forward to mitigate disputes of this kind.
Yeah, thank you so much for that, Kushal, and I agree. I think on this whole premise of are there enough protections in the market under existing frameworks, or do we need to see more regulation? You've really hit the nail there. The market can continue. There are a whole series of protections in our contractual frameworks, and of course, regulation helps, but that takes time. And when we're dealing with the challenge of the scale of climate change, we don't really have the time to wait for a perfect set of regulations. So as we saw in the renewables market, as we're seeing with energy transition for transport, in particular electrification of vehicles, the market's moving ahead of the regulations, and the regulations are catching up. Kushal, just on that point, but do you see the need for more regulation, or do you agree that we just get on with doing the best we can with these contractual frameworks?
I guess it's a spaghetti of regulations that we're talking about, right? So we have so many different markets. It's not one carbon market. You have domestic compliance schemes, you have international compliance scheme, you have a voluntary carbon market. Then you have the cross-border nature of it. Buyer sits in Europe, project is developed in Colombia, carbon asset developer is sitting in Switzerland, the insurer is sitting in the UK. So I'm not sure regulation will be able to capture all of this unless we declare that all carbon credits are securities, which I'm not saying we shouldn't do, by the way, but I don't think that the market infrastructure is ready to go to that point. And come back to the point there, we still haven't divided the roles correctly, who holds data infrastructure layer, who holds the power to issue and cancel credits, who holds the power to transact credits, and is that going to be a transparent platform, or are we going to go on doing bilateral deals? So I think the point is that we do need stability of regulation definitely for the compliance markets. That is clear. And as one of the panelists was saying before, every host country will have its own rules. And I think, therefore, that is what we should tackle first. Consistent carbon frameworks, just as we did in the power sector, so we had a playbook for every country, that this is how you develop your carbon frameworks to attract capital, institutional capital. And then you have robust dispute resolution mechanics, as you said. Things like investor-state treaty arbitration are really important, right? So, because as carbon credits in the compliance markets become more valuable, there will be a temptation to expropriate, there will be a temptation to do retrospective taxation. And at that point, investors and buyers, so government buyers like Singapore, Sweden, Switzerland, they will need the protection of bilateral investment treaties. That's not happening right now, and it is really important that we move towards it. And project developers as a whole consistently move towards it, because otherwise we can be divided and conquered, right? So this was accepted in that project. Why do you need this in yours? Why are you so special, right? So this consistency of advice and this consistency of practice, the same playbook repeated several times, that is what we need going forward. And the last point I want to just say is, I think capital markets can generally tolerate complexity. What they cannot tolerate is ambiguity. And I think this is what we will struggle with if we want to scale to the size that we all of us in this room are aiming for.
Thank you for that. And I just wanted to jump back to investor-state treaties. Joe, if you could take us through the role of those treaties and how they can be utilised in practice in the carbon markets, please.
Thanks, Ruth. And I think this is an important tool to have in your toolkit, because until there is more regulation, investment treaties do provide a very useful tool for investors either in the carbon credit market by purchasing carbon credits, or investors who are investing in the developer of the project. First, let me just step back and explain investment treaty arbitration for those who are less familiar with it. So it enables firstly I step back with the treaties. There will be a treaty between two or more states, and the treaty will provide investment protections for an investor who is a party of one of the states to the treaty. So for example, if there is an investor from Singapore, there has to be an investment treaty that Singapore has with the country in which the investor is investing. So say the Singapore investor is investing in Kenya. Kenya is considered to be the host state, and Kenya must provide certain investment protections that are set out in the bilateral investment treaty between Singapore and Kenya. Now, in the carbon credit space, there are two ways in which investment treaties are relevant. Firstly, for those who are investing in the carbon credits themselves. Here, there may be a way in which the government either changes the carbon credit scheme or even cancels it, as, for example, happened in Canada, where the Ontario government cancelled the carbon credit scheme. And that led to an investment treaty case brought by Koch Industries against Canada under the North American Free Trade Agreement. Unfortunately, in that case for Koch Industries, they were unsuccessful because the tribunal found that carbon credits were not considered an investment. It's important that you look at whether or not the investment is not just protected by the treaty, but that it is a type of investment that is protected. There are very broad definitions of investment in most treaties, which includes intangible and intangible property. Now, in this case, whilst the investment protections are governed by international law, whether or not there's actually an investment is governed by the local law, so Ontario law. So the tribunal spent a long time looking at whether or not the carbon credit scheme gave rights to property, intangible property, that was protected and recognised by Ontario law. And unfortunately, they found that this was not property, and so it was not a protected investment. Now, other jurisdictions may take a different view. Carbon credits have been recognised as property in England and also by the EU. The European Court of Justice has recognised that they are property, and so we may see a change in this in the future. And just as the previous panel talked about harmonisation of the definition of carbon credits and whether or not it is property or an investment is going to be very important to see whether or not investment treaties will provide the necessary protection. The second area is where there is a change to the project. So, for example, it may be that the land has been expropriated, or the licenses or permits required to use the land for the particular project have been expropriated, taken away, or somehow interfered with. And just as Kushal mentioned, this could happen in a number of scenarios, not only for expropriation of the land, but also for changing the taxes, the incentives, or in some way interfering with the investment. So some of these may be measures that are taken for legitimate reasons. So, for example, there may be Indigenous rights that were not taken into account of in relation to the project, or it may be for illegitimate reasons. So, for example, introducing retrospective taxes or incentives may result in an expropriation or may be considered to be a breach of fair and equitable treatment. Now, obviously, the state is trying to do this to ensure it gets a better financial benefits from the particular project. But in these particular cases, there would be a viable investment protection claim that the investor could bring under a treaty, assuming that it can find one that is appropriate for the particular case. And then if they can bring an investment treaty claim, it would just be like any other claim that's brought in arbitration. You're entitled to bring a claim for damages, and if you get an award, that award can be enforced under one of the applicable treaties.
Thank you, Jo. Really appreciate that. I'm conscious of the clock. There has been an excellent question that's come through from the audience, and I would like to touch this. It's one for you, Tom. So particularly in the context of CORSIA insurance, how are insurers managing this risk, noting that the risk of sovereign default, i.e. no corresponding adjustment, may arguably or potentially be an open-ended risk? We'll have to answer this succinctly, but because I want to do the key takeaways before we close out.
I'll do my best. The challenges around CORSIA insurance are one of the reasons that KETA has not offered a CORSIA policy yet, although good underwriters should be able to pick their way through these challenging areas to provide insurance. So we're going to have a go at it. I would say that when we have looked at political risk in the past, particularly and looked at the LOAs, what we have found wanting is and this goes to Jo's point, that it is a legally binding obligation on the government for them to provide essentially an export license for those credits. And secondly, in the event of a dispute, that it can go through to arbitration because, to pick up where Jo left off, for political risk to pay a claim, or at least to know how much of a claim to pay, usually it has to go through arbitration, and when where there is a default on the award, that is the size of the claim that the political risk underwriters will consider.
Thank you so much. So given the time, we might just start to wrap up. So starting with you, Tom, what's your views on how the current contractual and regulatory frameworks protect investors and end users? Are there any additive changes you would suggest from your perspective? And what would you like the one key takeaway today to be for the audience from an insurance perspective?
I think I'll pick up on just two points, just to make it fairly quick. One, we see a lot of damages clauses being inserted into contracts. I think whilst those are useful for aligning incentives, they have to be kept under control, because for developers it can be beyond their means really to meet those obligations, and ultimately if that means that the project can't go ahead, then the incentive is incorrectly created. And since I can see Chris in the audience here from GCMU, I'll reflect on Kushal's point about having a clear understanding of the ownership of the carbon credits and then any impairments that might have been placed upon them and all of the infrastructure that goes around that, so that we can think of these in the sense of a financial instrument in terms of knowing who they're owned by, how they can get transferred. That ought to be a risk that we can take away.
Thank you, Tom. And Kushal?
I think there's I also have 2 points. I'm copying you, Tom. The first point I have is that I think we need market recognition in a lot of these RFPs that we get around compliance credits, that risk has to be allocated to the party best placed to bear it. And the project developer cannot bear every single risk of everything that can go wrong with a carbon credit. It's not commercially viable, and it'll also mean that the market will stay stagnant. So you will see lots of tenders going unanswered, or only traders being able to participate because they're the only ones with the balance sheet to be able to do so. And that'll mean that the quality of supply will deteriorate because people will not have the capital to allocate for new projects, right? So if we want the market supply to deepen, if we want the compliance markets to be successful, RFPs have to be designed a lot more thoughtfully. And they have to already contemplate what happens if there's a change in law, what happens if there is political force majeure, what happens if there are unforeseen risks that cannot be quantified or modeled at this point of time. So that's one. And the second thing is on bilateral sovereign relations, right? Project developers are not in a position to go and bargain with host countries on what an LOA can look like, because it's not enough to actually get an LOA. It's really important what it says. It doesn't seem to be the focus at the moment, but it's really important what is written on that piece of paper and what happens if what is written on that paper doesn't happen, right? What are the consequences? So I think the consequence allocation currently is not clear. And not just is it not clear, it will lead to disputes and it will lead to bankruptcies, because the LOA is effectively the instrument through which you can get to sell a credit. If it falls apart or if a corresponding adjustment is not applied, the credit loses its value. You have to write it down to zero, right? So sovereigns have a role to play in making sure that there is investor protection for projects that are originated, and only they have the leverage to be able to do so. Project developers don't, and that's where they can help us.
No, exactly. And your comments are so relevant for the CORSIA market, because this is the real nuts and bolts of it all, and our encouragement to all participants in the market is to be talking about these issues up front and putting in provisions in the contract, because the reality that we're grappling with is, even if you get your LOA, you can't force a host country to give you the corresponding adjustment. So there's a whole lot of other work that needs to be done to get to that end result. So to you, Joe, for your final takeaways.
Thank you, Ruth. We've seen that the contractual legal mechanism will provide some protection for carbon credits. And of course, you have to have an effective dispute resolution clause. But I think there needs to be more work and more analysis of the investment protection mechanism. So firstly, as the previous panel discussed, and as the Ontario case showed, there is a need for some sort of harmonisation to ensure that carbon credits are protected and seen as a protected investment. And then secondly, the participants involved in the particular project as the purchaser of the carbon credits or as the developer need to ensure that you have investment treaty protection. So look at the available treaties. Make sure there is a treaty between the entity that is going to make the investment and the state in which you're investing. And if there is not a treaty, consider going to another country where there is a treaty. So for example, Singapore has many treaties as part of ASEAN in Asia, but there are not so many treaties in Africa. Singapore has treaties with Kenya, Rwanda, Nigeria, and Cote d'Ivoire. There are a few more where they've been signed but are not in force. But there are no other treaties with other African countries. So you may need to make sure your investment goes through another country.
Thank you so much. So thank you to everyone today. It's really been an honour and a privilege to be here with my panellists talking about these issues. We could have gone on for significantly longer. There were so many other things that we would have loved to address. So please reach out if you've got any other questions. I do want the takeaway to be positive. We're in an AI tech world, and it's actually the core human skills that help bring the most success to these projects. So good due diligence, good negotiations liaison with your counterparties, good liaison with the governments and the emerging markets that you're working with. All those skills are invaluable. So thank you everyone for your time today, and thank you to my panelists.
Thank you, everyone.